Hey, did you know that this past spring, the New York State legislature passed a bill that made sweeping changes to state landlord-tenant law? While most of the bill's provisions only pertain to the New York City County and its surrounding areas, many of the changes will have some significant impacts on the eviction process here in Western New York, effective June 14th, 2019.
Very interesting. Yeah, I already knew that. But did you know that when applying for an apartment, a landlord cannot, I repeat, cannot charge more than $20 for application fee, including the background check fee. Additionally, a security deposit is legally limited to the same amount as 1 month's rent. If a tenant is notified of any non-rent related lease violations, they now have 30 days to cure the violations, where before, they had only 10 days. If a tenant is behind on rent, the landlord now must serve them a 14-day notice. Excuse me? Like I said, 14-day notice of non-payment of rent. Previously, those notices only had to give tenants 3 days to make payment.
Of course I knew that.
Oh,
But did you know that a notice of petition for non-payment once filed must be returnable within the 10 days, doubling the 5 days that were required up until changes went into effect? Service of the petition, as required by New York law, used to have a time frame of 5 to 12 days that has been lengthened to 10 to 17 days. Additionally, the petition itself now may only ask for unpaid rent. Other charges such as late fees, unpaid utilities, attorney fees, and anything non-rent are barred from being included in the petition for non-payment and must be sought out from the tenant in a separate action.
okay. All right. Okay. That's good to know. Knew that, but I would bet my bottom dollar that you didn't know. Once a hearing is held on an eviction petition, either party may request an adjournment from the court. Until recently, there was no minimum length of time for adjournments granted. Now, all adjournments must be at least 14 days. Matter of fact, if a tenant does not appear, the court may grant the landlord a default judgment against the tenant and may issue the warrant of eviction. In such a case, no money judgment can be granted against the defaulting tenant. And finally, once a judgment of eviction and warrant is issued, the court must clearly state the earliest date the rent can be executed by the marshals. I said marshals. On top of that, where warrants used to be able to be executed 72 hours after they are served on the tenant, execution of a warrant now must be at least 14 days after service.
Yeah,
What's the 411?
I know. But did you know you're standing on my foot?
Oh, allegedly.
As you can see, most of these changes focus on the eviction process and how they are handled by the courts as well as the parties involved.
Yeah.
There are bound to be some growing pains
Yeah, there sure are.
and confusion
Oh, for sure.
as everyone gets used to the new rules, but we hope that by educating as many people as possible, we can minimize the potential harm to all those who may be involved in an eviction.
Okay. Listen, I'm not gonna, you better be glad that I'm not.
Did you know
Educate the people.
you
Did you know?
can learn best practices for better housing on tolastandards.org or
Check them out on Facebook
check them out on Facebook
or YouTube.
or YouTube.
Maybe Instagram. No,
All the above.
girl, bye.